Hello, regarding item 235, the old matter, my lord, is a 2014 matter, subsequently fixed in date, my lord. 2014 matter.
Just wait. We are actually, I am held up from 2 p.m. for another thing. So I will be regularly sitting in this bench from tomorrow. So don't worry. We just sat for one very urgent matter. Nothing. Otherwise, the other bench of the Honorable Chief Justice has to be conducted.
Tomorrow I will mention.
Please come tomorrow. We'll consider.
Lord.
We'll take only one matter, and thereafter from tomorrow we'll be sitting from 2 p.m. regularly.
No.
I was only, my lord, seeking leave to file an appeal without certified copy. This is in
Of this bench.
my lord, of this bench. Yes.
Group 2, Group 2.
My lord, Order 41, Rule 11, my lord.
When the order was passed.
My lord, order was passed, my lord, 2 weeks back, my lord. But then this is extension, my lord. My lord remembers, my lord, those group of matters which happened, my lord, on 28th of September, where an issue was raised because subsequently extensions have taken place, whether the appeal had stood infructuous, my lord. Then your lord.
When is the last extension done?
The last extension was done, my lord, on 2nd and 3rd of December, on 3rd of December, my lord. Yeah. My lord, these are bunch of
Have
four
you applied
appeals.
for certified
Yes,
copy?
we have applied for certified copies.
Next, the copy of the
yes
application for certified copy.
Yes.
You annex it, then
We will annex it and give
please.
it, my lord. Show it. Very well. I'll
Server
annex it
copy is there.
Server copy is there.
Lord, may I have the Lordship's leave to mention item number 5, Lord? It's the Honorable Chief Justice's division.
This is not a bench. We will be sitting after one matter. Just wait.
My lord, may I be permitted to mention a matter for inclusion of inclusion matter?
Determination.
This is my lord's determination. Order 41, Rule 11, your lordship, appeal.
Come tomorrow at 2 p.m.
My lord.
We'll consider.
Deeply obliged.
No one.
My lord,
I am for the appellant.
I beg to appear for the respondent vocational council, my lord.
I am appearing on behalf of state.
My lord, the order impugned at page 84 of your lordship's list. The admission is today up to 11:30 p.m.
তার জন্য বসে আছি, এটা তোমাদের তো একটা জানা উচিত। What is an urgency that it cannot wait?
Well, today up to 11:30 p.m. as per their own program at page 66, page 74. Lordship will look at the online admission will be today up to registration of the online registration up to 13 November 24. We could not, my lord. We have made the admission as per.
We do
at
75.
page 74. Page 70, it may be 74, 75, but there is a confusion in this
No,
camp
that is for
also.
pharmacy
It is
admission.
10 September 24.
No, I am unable to get it.
Bala got the 10 September 74.
Page you are
Page
referring.
74.
74 is a list.
75. Bala, there is a confusion.
75 is a notification of
Yes,
30th September.
That notification.
Yes.
Relying on. This is a notification revised academic calendar for the academic session 24-25.
Yes.
Mala, the academic calendar to be followed by the institute offering diploma in engineering, technology, architecture, and modern office to also 24-25 session. Admission is 23rd October 24 is the last date for admission to upload the admission details.
Where is the last date?
Right hand side admission column is there, Mala. Lordship will take it very fast. Step down from the written portion.
First bullet, my lord. Admission.
First
Admission is 23rd of October.
23rd October 2024.
That has
admission
gone.
Admission as per the direction has already been over in the college. No question of new admission.
Then?
Only uploading of the said portal. Mala, that portal has been missed by us. Mala, our admission is online admission and only a click.
So what you were doing for such a long time? 23rd of October was the last date.
We filed the writ petition, Mala, praying
Writ
for
file a writ petition and then the writ
with the
petition will be entertained.
college is
When
at,
you filed a writ petition, sir?
college is at fault. Mala, 153 students' future is at stake.
I understand, but what you were doing for such a long time?
Mala, we have pleaded, my lord, in 11th of November, we have given a letter that we have mistake. That has been stripped out. But that has nothing much to be done for that. But kindly look at page 66 for once. Page 60 is a government quota. Government quota, government could not fill up 75% of the quota of
I
the
understand,
students.
sir. So you could have.
Government has asked us to give admission. take admission. We have
Where
taken
is the,
admission.
where is the order of the government to give
Page
it?
page 66.
67.
67. Can you
67?
This was 9th August 24.
Yes, that much
Yes,
before.
we have done in terms of this direction,
What?
August direction. But kindly may I read for once?
Yes.
It's completely
This is
different,
to
my lord.
inform you that considering the poor admission in almost all private polytechnics,
Yes.
the self-admission provision for admission of college, first year and second year may be taken by the institute. Self-admission. We have taken self-admission.
From 13th of August, 15th or 13th of August.
We have
In the
taken
portal.
admission. Our part is over. Now, this total number of admissions, these are online admissions with us.
Did you upload this?
That uploading is mix. Only one
Why?
bottom
Why the site was given to you to upload
it
it?
was given to me, my lord. Only that is the mistake on the clerical.
Then why
portion
you
of the-
did not immediately come on 10th of August or 13th or 14th or 15th?
Yes.
No, the date was, my lord, on
From
sometime in
13th August.
October, the date was there.
So why you did not?
October was the date.
Why you did not?
23rd October. The
Why
date.
you did not upload it?
I have committed 17 days delay.
What delay?
11th of November, we have said, my lord, kindly permit us, we have committed a mistake. My lord, 11th November letter is there. If you lordship kindly.
Where is the
look at
letter?
Page 47. Page 47. 48. It should be 48.
What is this? This is a ground.
11 November 24 letter.
Where is that?
That is at page 80. মানে এগুলো এইখানে একটা করে 47 লিখবি আর এখানে একটা 80 লিখবি। 11th November, that is 48 page should be before your lordship.
Page?
11th November 2024.
80 or 81 should be,
80 or 81.
আমাদের 80 মাই লর্ডের হয়তো 81 হয়ে যাবে আমার একটা পেজ
That's a notification at page 80.
81, I am
Then, my
saying.
lord,
It
81.
should be 81. The letter written to the chief executive officer.
81.
But we have requested to reactivate the self-admission tab long before the last date expired, my lord. For immediately 17 days after the last date expired, we have
Now,
made a
my
plan.
lord,
And
and-
this has not been, my lord, dealt with that at all. They could have, my lord, considered it because the admission will be registration.
Why,
will be
my
on
lord? Now, may I say, my lord?
the both of them
No,
are-
October was the last date. You wanted to reopen it, reactivate for this purpose. 28th is a date for examination.
No.
Sorry, the December.
And yes.
20.
17, my lord.
17 is a
17
date for
No,
examination.
registration date is today.
Eh?
Registration date is
No,
13. 13 November is the
13
registration date.
November.
13 November is the registration date. Well, it will continue up to 25th of November registration. But admission, my lord, on 23rd October, we missed it. 11 days, we are 17 days, we committed delay.
What can be if it cannot be uploaded because they must have closed the portal on the after 28th.
Deficit students are there, my lord.
No.
Deficit
This
seats
is
are
what
there.
The
But
court
only-
will substitute to a academic system.
That is the difficulty, my lord. My
153
submission is
students have- 153 students have been, my lord.
We
got
understand, sir, but
They are
what
studying
has
in the
been done? কি করবো?
only-
এত late হয়েছে. And when the order was passed,
My
And
lord,
the
order
last
was passed
Friday.
on Friday. my lord.
Last
they
Friday.
came on 6/12.
Last Friday, the order was passed.
What can
But-
be done?
And my lord, registration is already, my lord, date 25th November could not be done because of the admission part, my lord, uploading was not
Obviously.
allowed.
Naturally.
Immediately, my lord,
If there is a technical latches, I can understand. But this is not a case of technical lapses or
clerical
latches.
latches, my lord, I
No,
tell you,
it's not a clerical.
uploading is only a pushing a bottom, my lord, it
No,
will
no,
be uploaded. Entire thing
Sorry,
is online.
sorry. That has
Entire-
to be done by you.
That is what I committed, my lord. I committed the mistake, my lord. I am ready to, my lord, compensate any loss to the authority. But if what time work is to be done, the compensation should be paid by us, my lord. Nothing to be further done.
এতদিন চুপ করে বসেছিল কেন?
And
Next tribunal, another 150. This is in one matter 150. Next matter is
no,
100.
that is all government quota has been transferred.
That is
to us,
altogether-
Fill it up. We have no student with us. Deficit students are running in the polytechnic. The institute,
that
my lord,
is-
is, that.
Sir, that is
Fixed up,
understandable. That was done much in the month of
August.
August.
That was the,
It was done prior to August.
yes,
You did it everything. Why their portal was open?
Oh, no.
Why you did not approach immediately?
yes.
That's
No, no,
you have played with the career of the students.
My lord, we are, my lord,
You have played
we
with
are
the
facing,
career.
my lord, a
How can you?
turmoil in
No, this
college. my lord.
cannot be
Lord,
done.
you will kindly save this, my lord.
What save? Tell me the law that the court can
No,
say.
I am only praying this, my lord. This will not cause
Can
any,
it be done?
this will not cause any, my lord.
Give us any precedence that the precedence has been given that the government has allowed anyone previous.
Previously, my lord, it was,
Show us
I
one
understand, my
instance.
lord, that previously it was so done.
Previously,
Show us where you have stated. Show us where you have stated one instance that it was done.
Only lapse
No,
of, my lord,
no, no,
some days at the
that is
clerical
the-
mistake, lord.
So
The
this is a clerical.
students of
The
100
clerical mistake can be of a day or two. I can understand.
it's a chup bol.
You should have immediately approached them. You approached them within time. They did not. Immediately you should have come before the court.
11th November we approached.
No.
True. Why the 28th was there to 11th November you waited. Why not immediately or after
Yes.
11th November you approach the court?
Actually, it does not make any profit to this college, my lord. We are not getting any privilege out of that, other than
No,
accepting the
whatever be
suffering.
there, I understand what is your predicament. Your predicament is that you will lose lot of the fees which you have collected from
Yes.
those students.
And students' future, I am returning the fees, no problem. But the students'
Return the
future, my lord,
fees.
they have completed.
Return the fees.
They have
This is for second year.
First year, second year, it's not second year. That second year for the lateral entry for the +2, for the
third semester exam.
12
We have
for the 12
completed first
student.
semester.
All are new admission.
These are
But
all new admissions.
All new admission, and it is not a question of uploading. That was the first admission through online.
Admission.
It was closed,
Admission
then
directed to
registration.
be done by us as per your own letter.
Then
Why
registration
you did not
comes.
do
I
it
have
when you
done it, but
admitted?
I have admitted it.
Then
No,
why you
that
have
is
not
we are not
appropriately
aware of.
approached?
We
That
should not be aware of that. That is their internal
that
issue.
notification has been given by them.
We understand admission
Only
when it is
to
uploaded.
upload the same.
Can't help it all.
Clerical The authority may
Yes.
otherwise considering the plight of the students, may consider the prayer of the petitioner, if at all permissible under law. Malar, kindly add one line. My lordship,
Due to axi.
lordship,
Yes, yes. In
Lordship
view of the dismissal of the for the same.
lordship is generous, malar, kindly only
Sometimes-
one. prayer.
Sometimes, no. Maybe Mr. Komaraj Bhattacharjis have a persuasive appearance. That does not mean the law has to be.
Not at all. Not at all. I have
Sir,
not any
we can't.
special. I have only the students. Lordship,
I
consider,
understand.
the authority
I
consider.
understand. I understand.
Everything is not
Still,
with me.
we have not said we should direct the compensation to be paid
But, well, this is an original site mention. When it is appearing as item number 98 in the original site, there is some urgency. The compliance report has to be filed by Friday. It's one of the incentive matters.
One of the
Incentive matters, my lord. Compliance, if my lord can be taken up any day on Friday or
site when it is taken up.
Today one at 12.
12. Let us see.
98 possibly it will not reach.
Why you
My-
underestimate the pace of the court?
My lord, I'm not underestimating.
What you are doing? Wait.
Milord,
My lord, if it is not taken up,
let us
liberty
see
to
that
mention,
Friday
my lord.
again we are sitting.
Milord,
Yes.
Milord,
Okay, the mention-
Praying Milord's kind leave to file a new appeal matter, original side, Milord, after the delay has been assessed yesterday due to some technical glitches at the E-Shiva Kendra, Milord, it could not be filed online. So I have been told by the filing section that if Milord grants us the leave, then physically they may allow it. Because even today, the online is still not active, Milord.
Why?
There is some difficulty. So since the delay is assessed, my lord, I'm praying for my lord's kind leave, my lord. I'm ready with everything, my lord. Because they don't,
Not the- Yes.
my lord, there are 3 connected analogous appeals. my lord.
Here,
Milord,
they have to
Milord.
cite original side,
Appellate side,
leave to file in a physical form.
appellate side daily list, serial number 1.
It is that matter, my lord, where the maintainability,
That matter we don't.
my lord, where, my lord, this appeal, your lordship directed me towards Ramkishan Fauji, my lord. That appeal is
Maintainable or not.
not maintainable. My lord, I have looked into it, my lord, and your lordship's absolutely, my lord, correct, my lord. But there is one aspect, my lord, which I want to explore with your lordship. If your lordship thinks, my lord, there is some merit, your lordship will give me a chance.
What are you talking about?
I'll-
When the appeal is not maintainable, how can we enter into a merit?
No, to show how it is meant, if possible, on facts.
The judgment of the Supreme Court is staring at your face.
But, my lord, I have also learned from your lordship, my lord, every judgment, my lord, is facts based. My lord, if I can distinguish,
Facts are clear, very clear. If the writ court exercises a criminal jurisdiction, clause 15 does not lie.
yes, and bow down.
Then clause 15 is gone.
But thereafter, my lord, only, my lord, if your lordship thinks there is some merit in what I will say, my lord, otherwise I'll not waste your lordship.
Only one thing.
Yes.
Referring to matter to the larger bench, we have referred the matter to. You have not brought those to coordinate bench
I have, which is
Justice
why I'm.
Abhijit Banerjee's judgment and
Yeah.
Justice Radhakrishnan
And
judgment.
there is a Supreme Court also, my lord, 2022, which is also a 3-judge bench, where, my lord, intra-court appeal, my lord, said it should have been decided in intra-court appeal because the foundation of the writ petition, my lord, was different. It did not arise, my lord, from any criminal proceeding or
Is
investigation.
the criminal proceeding.
No, subject to correction.
Quashing of the FIR is a criminal proceeding,
There may be other.
criminal jurisdiction. What are you talking? Ramkrishnan Fauji, that's the judgment.
Agree, my lord,
And your first prayer is a quashing.
but the foundation is
Foundation
because the
means what?
infringement of Article 21 and 19(1)(g.
Everywhere, in every bail petition, there is an involvement of Article 21, right to liberty.
Now here also,
Everywhere. So according to you, no bail petition could be filed. Everything should be filed in Article 226.
No.
That is what your
if
contention
I have
is.
paid my money, I am saying the foundation.
Whatever is the merit.
I will go to the Supreme Court if your lordship don't, my lord, I don't want it to be
not maintainable now.
Then, my lord, before Supreme Court, I
No,
will.
then,
go after-
then we will refer the matter to a larger bench.
Very well, then, my lord, I'll go before the larger bench then.
So, এই ওই অর্ডারটা দাও তো আগের অর্ডার একটা ছিল এটা আরে কল্যাণ বন্দ্যোপাধ্যায় Mr. Kalyan Bandyopadhyay appeared in that matter where
This Supreme Court, your lordship does not need to. Take the-
Again, that will come because if there is a coordinate bench decision of the Supreme Court, then in view of this Center of Dawoodi Bohra Community 2005 judgment of the 5-judge bench, it says that the latter judgment should not be
Or
considered to
previous
be
earlier.
the correct one. So earlier will prevail. So we do not want to enter into this. Go and argue before the larger bench.
Serial number 2.
See, I'm appearing for the writ petitioner's appellant. Let me submit.
Just give us 30 seconds time
Ma'am.
to go through the impugned order. What is the wrong in the order?
My lord, almost 18 months have passed, my lord. The
What?
CID has not completed yet the investigation, my
That
lord.
is the scam. Have you seen the sequence
Yes, my lord.
of the steps have been taken?
My lord, in the
Person,
yes,
the company which is non-existent, you have deposited a lot of money there,
yes, my lord.
and thereafter nobody could trace out. There is no existence. Ultimately, they could find one person. Investigation is to be done,
My lord,
and this is I would say these are the Ponzi companies.
my lord, kindly
Yeah.
consider the first order of the writ petition, my
18
lord.
months, what more? सब नियेছে step মানে
My lord, there are some,
তেলেঙ্গানা থেকে company is there in the Noida, Uttar Pradesh. ওখান থেকে পুরো ধরে ultimately তেলেঙ্গানা থেকে one gentleman has been arrested. Attachment order has also been passed.
my lord, CID West Bengal has again prayed for 6 months time, my lord.
We can, sir, this is the investigation. Are you aware? You are not aware of how the investigation is done.
My lord, kindly consider, my lord, the FIR was registered on 18th October
I
2020, my lord.
understand, sir, but these kind of a scam, it requires a lot of things to be gone into. That channel has to be found out.
But they are sitting tight, my
Or
lord.
they
They
are
are not doing
not
anything.
sitting tight, sir. All the steps have been indicated in the order.
Since
No.
then, I have, my lord, asked my client to take the updates, my lord. They are not entertaining my client, my lord.
What entertaining? The investigation is going on. What more?
They are not
No,
updating anything, my
nothing.
lord.
Nothing.
My lord, kindly consider there are 2 representations also I have annexed with this.
You can do anything in a criminal investigation. The victim will go and say that give me every document what you have done.
The honorable single bench have not considered that representations also, my lord. The representation is at page.
অনেকটা করেছি। আর বলেছি যে expedite কর।
My lord, annexure P3, page 31, my lord.
Absconding. Proclamation has already been done. Attachment of properties of this Ghulam Saifi is done. What
My lord,
more?
My lord, annexure P3, page 31 of the writ petition, my lord. The representation has not been considered.
Sir, I am asking, are you aware of the criminal law?
Yes, my lord.
What is old act? I remember 173.
Yes, my
What is the role of the investigating officer? They can pray for extension of time. If it is done, then the default bail clause will not come into their aid.
My lord, the petitioner has lost his both parents, my lord, which could not.
But
treatment.
why with the closed eyes, why you invested the money?
That is.
Why you invested the money, sir? Don't you have any kind of a sense that whether these companies are really in existence? You are lured, you fell in trap.
That is his.
As a responsible person, you must have a responsibility. Every day we are getting the news. And the awareness program is extensively undertaken by the RBI. Every citizen of the country is made aware that don't invest, don't get lured. Somebody would say that I will give you a 36% interest per month. You are lured.
My lord, in the Corona period, they have my petitioner has done
But
such.
they are doing it. They will recover everything. They have attached the property. They will sell. They will get the money. Everything
They
they will do. it.
arrested
What
only
can be
one,
done?
accused, my lord.
Since you have a resources engaging all the galaxy of the lawyers, so there are other innocent persons who cannot, and they don't have the resources. That was the only resources that have gone. Look at their plight.
But my lord,
You have other resources you can engage, or your client have engaged such a number of the lawyers.
my lord, right to speedy trial, my lord, is right.
That's a fundamental. This a trial means the moment the trial commences, when a charge is when the case is committed, charge, then the trial. It's an investigation stage.
But money has not been
Speedy
recovered.
trial is a different concept. These are at the investigation stage.
But for the sake of trial, my lord, money is not recovered, my lord.
Come. default bail. Kindly, they are going for your benefit. If they do not ask for extension, then the application for bail, default bail will come. So look at their genuine efforts. What are you talking about?
Money has not been recovered, Mother.
What?
No money has been recovered. Till date.
What can be? Sir, the property has been attached. What do you think? A allegation has come, so you think that everything is like a omnipresent? Everything they will grab it. I would be happy if that system comes. I think one of the best system in the world that the police authorities are omnipresent. They know everything. They can do whatever you say.
Well, lacuna in the investigation.
Investigation will take time, sir.
18
Sir,
months.
are you aware of the criminal law? When you are talking like this, then it appears that you have no knowledge of the criminal law. You do not know the effect of those investigation, how it is to be done. Sorry. Next.
Serial number 3.
My lord, my name is Dipankar Chakraborty. I'm a doctor by profession.
Yes. Take your seat. Give us 30 seconds time to go through the acute order.
Final order টা কোথায় আছে? ঠিক আছে। ওরা in-person ফাইল করছে তো খবর কিসে? খবর দিয়েছে বারবার। Verify session plan. Sir, everything has been provided to you. Every relief has been provided to you.
No, my lord,
Within the competence of a writ court, I think every relief has been given to you.
no, my lord, I have a few things to say. That the reliefs which have been given are not relevant because the points which have been listed to go to the medical council, medical council does not have any jurisdiction to see those cases, those
No.
things.
If there is a medical negligence,
Medical negligence of
There is
medical
no difficulty.
professionals. Medical negligence of medical professionals. But in paragraph 8 of the judgment, the list of
you have already approached the commission also, the consumer forum.
yes, my lord.
So that can be also looked into by a forum so far as the medical
No, my lord.
negligence.
The problem is that the essential problem from the very beginning is that they are making it a some treatment protocol problem, but there are certain very, very serious hospital problems which are not under the jurisdiction of medical council. They have spoliated documents, spoliation of documents.
That is what I find the single bench has also said that you can approach the police. If suppose any documents is fabricated, forced, manipulated, or something of this or changed, I think that it requires a proper investigation to be gone into by an investigating agency.
My lord, spoliation is a civil wrong. It is not a criminal wrong.
Which one?
Spoliation. Spoliation in the Western world has been rocking during the last half a century, and it has been taken as a civil wrong. It is not a criminal wrong. And
Fabrication, if there is a fabrication, manufacturing of the documents, changing the documents.
yes, that is spoliation.
That's I think the forgery is coming under the now Bharatiya Nyaya Samhita. It has come.
Provided I go to the criminal, because I had three options. I could have gone to criminal, to civil, or to consumer forum, all or anyone.
Yes.
So I didn't choose any criminal approach. I went to civil.
Now,
And-
suppose if you come to a civil,
And that spoliation is strictly civil. Strictly civil.
how one would ascertain?
Because there is documents.
The documents have come. The documents have been manipulated. The documents have been changed. Now, who is having the proper custody of those documents?
They have the exclusive.
So that is why the investigation is the proper mode that they will go and make an investigation.
No
The
investigation
court
is necessary.
Cannot go and make a roving.
No, my lord, no investigation is necessary here.
Then what?
Because there is so much of contradiction amongst their own documents.
Yeah.
There is so much of contradiction that proves itself that those have been doctored. That does not require any police investigation.
Then it's the commission who is the
Yes.
authority to take.
Yes, that's exactly
Commission-
for which.
The commission has been approached and the court has said that you can ventilate that grievance before the commission.
Commission is a different thing. Commission, I went there.
Yes.
Yes, I went there.
So that is
And-
what is recorded, that you have already done so.
Yes, in commission.
Yes.
My lord, Clinical Establishment Regulatory Commission.
Yes.
There, they have the jurisdiction.
Yes.
And there I went there. They just kicked me out. They did not allow me to submit a single sentence. And that is the reason why I had to go to the writ court.
No, are you challenging the order of the clinical?
Yes,
the
that's
commission?
exactly what I did.
Where?
That's
You have
exactly
also
what I
gone to
did.
a Consumer court.
Consumer court has given some
have gone to
revealed
the
some
consumer court.
documents. Or Consumer court, because I have gone, my lord, let me summarize this thing, that when I found that there were contradictions amongst these, I realized that the entire situation has been changed. The entire diagnosis has been changed. The entire thing has been changed, and they have created a new story, the not actual diagnosis and not actual cause of death. So I approached the Clinical Establishment Regulatory Commission with those things. They transferred me to medical council, who don't have the jurisdiction to deal with this hospital problems. So I waited with the consumer forum to have some admissions or statements on oath in affidavit form from the hospitals.
Correct.
I collected them. I submitted their an interlocutory application, which they call miscellaneous application for discovery of documents against the two hospitals. The hospitals replied, and then I came back to this Clinical Establishment Regulatory Commission, and who just did not allow me to say, speak a single sentence. It was infringement of natural justice, my lord. I went there for this purpose, that the commission has a jurisdiction, and therefore they should listen to me. And they just hooted me out. I said only 2 sentences. That so, sir, you will not listen to me. I will have to go to a higher court for submitting my grievance. You may go anywhere. You may go anywhere. You may like. This was the approach, my lord. This was the approach of a judicial system. I was not allowed to speak.
That is not a commission, is not a judicial system. It's a
Anyway, that is,
quasi.
they have the jurisdiction. They have the jurisdiction, and that's why I went to them. And your lordship may refer to this. My lord, just a moment. My lord, who have brought those documents here, my lord.
Show me your red petition.
Yeah.
Where is your red petition?
My lord, last time the Honorable Chief Justice's Division Bench passed an order to submit all those documents. I have brought them in form of paper books, my lord, and I have served all the respondents with the paper books. My lord, in the paper book, your lordship will find this.
Order can be passed at this stage because this is an application stage.
There is no scope for
It's an
stay.
application stage. The nature of the order which you have sought for, I believe this cannot be granted at this initial stage, at the interlocutory stage. It needs to be decided only after the full-fledged hearing is
Yes, my lord,
undertaken.
I am ready for that.
So that is why then.
My lord,
the
just a
preparation of-
moment, my lord. My lord, kindly come to volume 2.
No, you are asking for quashing. Quashing cannot be done. It has to be done at the time of final hearing.
Final hearing.
At the interlocutory stage, court will not, then what remains? Appeal, nothing. And then you wanted to cancel. This is also a final
My
relief.
lord, so far I have,
And compensation is also to be judged on the basis of the
Final hearing.
entirety.
my lord,
And therefore, I believe that the matter has to be matured for hearing.
For such reason, my lord, there was a direction to file the paper book. My
Where
lord,
is that direction?
yeah, my lord,
his direction is
I believe, my lord, that was,
that is 5.
Justice Bhattacharya was there at the time of hearing.
I was not there, so I.
No, my lord, I know.
My lord, the thing is that
Lord, I tender my unqualified
I can
apology, my lord.
produce a
Initially, it was.
my lord,
Yes,
I
there was
can-
a direction for compilation and I have been served. I cannot deny that. I have been served the entire.
My lord, the thing is that I have a lot of judgments of the Western country. There says that once spoliation is proved, the case is closed. You have no case. That is exactly they say. Spoliation is proved. That means the spoliatorum something. That is that. That means the spoliator has gained advantage,
To be
and
counsel.
it would have been a disadvantage to me. Huh? So once the spoliation is proved, the case closes. So I have come with a lot of documentary evidences where spoliation can be as clear as daylight.
Did you produce those documents before the trial court?
Trial
I
court,
mean, trial court means this before the single bench.
yes, yes,
Did you produce all those documents? that
yes.
they were
I
there?
have annexed all those documents which I produced before the commission.
Yes. No,
commi-
in the single bench also?
Yes, I have annexed them. I have annexed all the documents that I produced before the commission, and the commission. Why not let me produce that my evidences? I can't produce my evidences. I can show that daylight, like daylight, there is difference between the.
Where is your writ petition?
in the form of paper book, if you look. Volume 1 থেকে পুরোটাই রিট পিটিশন আমাদের কিছু
পেপার আজকে ফাইল হয়েছে না আগে হয়েছে?
Volume 1 is completely writ petition. Volume 1, there's.
What is the prayer?
I have come before the appellate court for
Yes,
justice for my daughter, deceased daughter.
No, I know.
She has been killed.
So name was not, their names were not recorded in that particular clinical establishment. They are also positive. Their first prayer is this. And the license has to be concerned of these two hospitals. Where is the complaint? Which you filed before the commission?
Commission.
Which page? And where is the final order of the commission?
What are the final orders?
No, no,
Are
first
first
was the
complaint.
complaint and then the final order.
Just a moment. Complaint of the. My lord,
45
just a moment.
not page not 45
Page?
52 running page 52 not as it has been indicated running page 52 of the volume 1.
No,
Yes, my
it's
lord.
an application.
Application dated 5/12/2022.
No, no, I'm talking about the complaint.
Yes,
Oh,
that
this is before.
this is the application.
Yes, my lord,
report,
that,
yes,
that was
45. 45
Yes.
volume 1.
my lord has got it page 52 I believe.
Just wanted to look at the prayer.
Hello. Page 72.
Thank you, sir.
Where is the order of the commission?
Commission, order of the commission, that
Volume
that
2.
is the first one.
So on the basis of this complaint,
Yes, on the basis.
what
of
is
this
the order?
Well,
passed by the
first that is 173 of the volume 2. Well, first order that is interrogatory order. Thereafter, the final order has been passed. That is at page 200.
200 of
First 173.
173 is expertise. That is the difference.
That is
2, my lord.
first
Volume
thereafter.
2, 200.
Initially, my lord, the order was passed ex parte. Thereafter, my lord.
Just one.
Yes. My lord.
Now, where is the final order? Page 200.
Page 200, my lord.
But this, by this order, the complaint was disposed of. Then what is the final order again?
No, my lord, 173, it was initially ex parte order, thereafter again.
In its presence, it was disposed of.
No, my lord.
No, page 200, my lord, in his presence
So
it has.
complainant was not the witness.
Yes, my lord, that.
Actually, the thing
Thereafter
was that
200,
I,
he filed an application for
I-
recalling. Then page 200, my lord, this order.
I could not attend because I had a emergency pediatric patient.
Whatever.
And also I applied for a rejoinder, submission of a rejoinder. So the next hearing had,
Next.
My lord, kindly come.
Is a commission president.
My lord, may I submit something? My lords, may I submit one thing? My lords, kindly come to page 204. Mrs. Jayati Chaudhary, learned advocate representing the CEs, would contend the complainant has already approached the consumer forum. Hence, the complaint would not be maintainable before this forum. That is error of law. Anyway, next, since we are disposing of the complaint without any interference, such question may be kept open to be decided if occasion so arises. Now, in the consumer forum, the occasion arose, and I came back with 214 milers. Kindly 214.
No. What is the spirit of the order is that the commission says that the nature of the allegation which you have made before it does not warrant any interference at this stage because it all relates to a medical negligence or a lack of medical protocol.
Yes.
So it is the Medical Council of India who is the authority to consider because they have to constitute a board, they have to evaluate everything and they will have to come.
Their
whether all the
jurisdiction.
medical protocols have been followed or not followed. The commission says that in the event if you get it, you can again approach to the commission on the basis of those documents. And therefore, the commission will do it. Since a point of demo was taken by whatever the lawyer who was representing the clinical establishment, that the commission loses its jurisdiction in view of the consumer forum having been approached. The commission has said, I am not going to enter into this point. I am keeping it open that in the next round, if you come, then if they take this point, then we will decide.
Absolutely. Yes, my lord.
This is what the spirit.
Yes, my lord. My lord, kindly comes. My lords, kindly come to 214. My lord, 214. I came back to them with a fresh application.
No. After the medical council was approached.
Medical council has been approached. I have
What is the
submitted
finding
both
of
the
what is the
simultaneously.
finding of the medical
Medical council is not responding at all
Why?
because they don't have any jurisdiction into this.
Why they don't have?
Because they don't have any jurisdiction on hospitals.
Protocol, suppose just to understand the because you are an expert in your field, you know better. So in order to understand that what is this? A medical protocol, if that is to be adhered to, there is a set norms, standard norms that a doctor, when a patient is brought, these are the protocols one has to follow. Clinical diagnosis, and then the other histological, I do not know.
Investigations.
Investigations are there. So those have to be done. So first thing is the clinical, I think the examination or analysis have to be done. So in that event, there is a set standard form, whether those standards were strictly followed or not followed. It's the Medical Council of India because they have,
Yes, my lord.
they have
Your
framed the rules.
your lordship is correct. Medical Council has two jurisdictions. One is medical education, and two is the product of the medical education.
Absolutely.
Product of the medical education, that means the licensed doctors. They don't have any jurisdiction on hospitals.
Can they not set a norms or a standards that what should be the parameters or ethic or the moral
Exactly.
of a doctor?
Of a doctor, my lord.
No,
Doctor.
you're talking about a doctor.
No. There is the difference.
Because you are if there is a lapses on the part of a clinical establishment only.
That is the thing, my lord. That is the thing I am telling.
No, sir. What you have done is you wanted to include or impede the doctors who have done. You say that when there was an oxygen saturation of 44%, then medical protocol does not provide or does not, I would say, recommend any intubation to be done. And this was done. So I think you wanted to.
That part I didn't include in commission. I didn't include in commission.
Included in the commission.
No. That's just by the by. By my complete, this is my lord, 214. This is complaint petition against spoliation of documents and other infringements of West Bengal Clinical Establishment Act.
Yes.
I haven't gone to Medical Council because under section 38(3) second paragraph of Clinical Establishment Act, it is clearly written that the issue of medical negligence of the medical professionals is under the jurisdiction of Medical Council.
This is what I was.
Yes, my lord, I know that. I know that.
Because the entire.
I know that.
So integrated.
That may be integrated, but
Great,
if
that
there
is
is no
what we
extra
wanted.
machine, if there is no extra machine in the emergency, is it doctor's fault? Is it doctor's fault or is it Medical Council's jurisdiction? If there is no ultrasound.
No, that is what is the clinical establishment that will be coming.
They are not listening to it.
They have also said that in order to establish a clinical establishment, they must have those
Yes.
infrastructure.
And they are not listening to that. That these are the hospital service deficiencies, not the medical service deficiencies of medical professionals. They are a very good.
Would have been the simpliciter allegations then, but since you have made it so complex by including the medical professionals into then everything gets so infused into it. Then
I have clarified.
The commission.
Then I have clarified. There is no problem in commission, my lord. Commission is a very good cook. Whatever batter you give, be it batter of paratha or batter of pizza, they create a good puri, whatever you give. They form a puri of medical negligence by medical professionals and serve it to the Medical Council.
Yes.
They always shrug off. That this is clinical protocol problem, so go to Medical Council. And Medical Council does not respond because they don't have any jurisdiction into that. Therefore, there is a clear distinction between the two jurisdictions, and that should have been heard of. They just kicked me out without hearing a single sentence. So who will decide? The list of allegations listed in paragraph 8 of the writ judgment, none of those are within the jurisdiction of Medical Council. None of those. So Medical Council will keep quiet, and my deceased daughter will not get justice because there is a jugglery of jurisdiction, underutilization of jurisdiction, infringement of natural justice. So why not certiorari? Bring all those documents here.
I understand, but the law has to be applied in the perspective of its object and the purpose for which it is there. Transgression of a domain is always, I think the Supreme Court or the courts have said that you can't. You have to work within the four corners of the domain or the powers which is given upon you. The question is only that whether they have transgressed the power or they say that they can't transgress the power. The powers are very limited. Then the only question which we have to consider is that it is within the contour of the law whether you were given an authority or the powers to decide this or
They have given.
Now, question is again, that's under the Clinical Establishment Act, what is the power of the commission? What they can do it. Now, there must be an element of those requirements to be pleaded in a petition which is to be filed. You are referring us to just in order to, in pursuit of a justice to be imparted, we are putting so much question just to understand. You have said many things.
My lord,
but
as you said, your lordship said that in reference to Clinical Establishment Act, my lord kindly comes
so
to.
this commission is established under that act.
Yes, very good, very well. My lord kindly comes. My lords kindly come to page 178.
Yes.
It's a rejoinder. Rejoinder to the first petition.
Yes.
My lord kindly come to page 181.
Yes.
And henceforward, your lordships will find that in every paragraph, the concerned section, infringement of the concerned section of Clinical Establishment Act has been mentioned.
Just 1 minute. Which paragraph you are talking? You are
Paragraph
referring to
5,
paragraph 4 onwards.
paragraph 5, paragraph 6.
Just give us 1 minute time.
One more.
Hmm?
Well, there are more paragraphs where I mentioned paragraph 7, paragraph 10, paragraph 11.
He has raised several issues. Is it not Just watch the list, it will be printed on the, in the list. Does not come.
এই প্রথম কি 62662
Well, the appellate matters would not be taken up anymore.
Original site. Original site from 12. So
251 days. To copy. Oh. Okay, they put it up, put it up.
After original side, we will take up the regular payment.
not possible. Today we sat in the morning for one urgent matter. From tomorrow we'll be sitting. For our Yes, call.
Original side item number 1, Principal Commissioner of Income Tax 2, Kolkata versus MS Anjani Putro Nirman Private Limited.
Here there is a delay of 251 days.
Service.
Service. Received by them on 29th of November. That is the speed post recording. We had sent by speed post.
Order of the ITAT. What is the substantial question of law?
Will a substantial question of law. His number to be on. Millard, the stay petition your lordship will take, Millard, at page 8. Page 8, Millard.
Towards from the memorandum.
Memorandum, আমার কাছে নেই, memorandum নেই।
It is like a second appeal. You will have to indicate, we have to frame the substantial question of law.
Yes, Millard. Millard,
This pertains to which financial year?
this is Millard, pertains to the year Millard, assessment year to 12-13.
What was section 260 at that point of time?
At that point of time, it was same, Millard, there was no
Changes
amendment.
have been brought.
No amendment has been.
Was
এই বইটা দেন আমাকে।
What is the demand? What was the demand?
Millard, it was tax effect is 2 crores 11 lakhs. 2 crores 11 lakhs.
You wanted to reopen the
Yes,
assessment.
yes.
Section 143.
140, 143 no 148.
143.
143 dead with 148.
After how many years?
Millard, ITT order, assessment year order.
At 23, 2023. ma'am.
Well, more than
But
10 years. More
Millard,
than a decade.
that is Millard, the tax tribunal ITAT order is of 23, but
The notice.
the
Reopening the
assessment order is Millard at page 19. Millard,
It's 13 of the state petition.
13 ki. Oh, Millard 19, I'm sorry, Millard, it is 13 at page Millard 13 of the state petition. It is date ta Millard,
এই তো 26
it 21/10/2016. 21/10/2016 is the assessment order.
of the return filed for the year 2012-13,
Millard,
13-14.
12/13. Assessment year 12/13.
3 years you took to pass an order.
Millard, this is within the time.
5 years is the initial period or what?
No, if it is more than 50 lakhs, then Millard, it is about 10.
I'm out of touch for a pretty long time. I'm just trying to recapitulate everything.
Millard, initially it was 6 years and then it became 10
Extendable
years.
for a period of this.
No, then it became by amendment, it was 10 years. Millard, today, Millard,
It came when?
in 2021.
Can you apply retrospective?
No, I have by that time, before the amendment came, I had passed my order. The assessment order I had passed before the amendment came. So, Millard, I am within the time, within the, even in the unamended
That
section.
is what unamended section says. What is the period?
That is 6 years.
6 years.
Millard, may I say this?
What
Millard?
was the ground? Escapement.
Yes. Yes, Millard. He did not file Millard proper return. Millard, may I say this, Millard? Millard, today, Millard, as my lord, the Chief Justice used to do, Millard, he used to condone the delay on a one particular day and then thereafter he would admit the appeal.
No, just I want to find out the merit
Yes.
first. If it is an unmeritorious appeal, what is the proper use?
Millard,
Was that section 263? এটা ট্যাক্স পেইন্স নয় তো এখানে থাকবে না 1 নম্বরেই
এই
আছে
যে 263 তোমারটা দেবে তো 263 দেখি দেখা আমার কাছে বলতে পারবে না ছোট সময়টা দাও
এই ফর দ্য টাইম বিং একটু ইনকাম ট্যাক্স যেটা আছে একটা আনিয়ে নাও
এটাকে চ্যালেঞ্জ করে আবার এটা এটা সূর্যটা পার এটা if we find that many assessing that we have jurisdiction not second time. Malad assessing officer প্রথমে একটা 143 হয়েছিল তারপর 143 266 হয়েছে সেটা ওর করে দিয়েছে তারপর আবার 260 yes Millard, perhaps Millard, I have a very bad case Millard, because in this case there were two 263 orders.
Then
The first one, the revisionary order was passed, and the second again he passed the same order. So, Millard, the tribunal held that a revisionary power under 263 can be exercised only once. Millard, there, Millard, the tribunal is correct. Millard, kindly, Millard, Millard,
what is the
kindly
power under section 263? Power is conferred upon whom?
Millard,
What is that power under section 263? That's the
Revisionary.
suo motu. Is the suo motu power of revision.
yes,
True.
yes.
To be exercised by whom?
The PCIT.
Can he revise his own order?
No, once an assessment order is passed, thereafter 263 order is passed, and then again it goes back.
No, there are two, because I find three eventualities, either for fresh or he can also do it.
Yes, he can do it. Now, Miller, the only thing that I wanted to show you,
Three eventualities are contemplated in the section.
Miller,
What he can do?
what tribunal has held, Miller, kindly take page 33 once.
It says that once the revision power was exercised in respect
It
of
could be done only
of a
once.
assessment order, then
Yes.
if it is reverted back and again assessment order is passed, it is not
Then
revised.
you again cannot do it. Millard, kindly allow the Millard the delay.
Where is the judgment of the Calcutta High Court?
Millard, I shall get it. I shall get it, Millard.
The ITAT has relied upon the Calcutta High Court.
Yes, yes. Millard, this
Two
Calcutta
decisions.
High Court, I see that it is not reported perhaps. Millard,
If the High Court has already decided it, then
yes.
then
Millard,
substantial
that is
question
why
of
I
law.
am not pressing Millard before your lordship, Millard, to allow the appeal. Millard,
Not allow, admit the appeal. We may not admit.
but condone the delay, Millard. The delay should be condoned.
Why?
Well, kindly only 200 and 200 days delay, 251 days delay.
Only
Kindly.
Have you read the judgment of the apex court delivered on Monday? Only what is interpreted there in relation to a condonation.
Kindly allow the condonation of delay, my lord.
Can't be, because read the judgment of the Supreme Court. Explanation must be there.
Explanation is there.
From where?
The explanation is from my lord, if your lordship kindly takes the condonation of delay, the reasons for filing the condonation petition is given at page 3, paragraph 3. Let each and every day has been explained.
Every day is explained. When the order was passed by the ITAT?
My lord, ITAT order was passed on 8th of December 23.
8th of December. Then what you did on 9th of December?
The order was received on 6th February
Why?
24.
Why?
He applied for the certified copy and it was.
Then what steps were taken thereafter?
My lord, thereafter on 7th of February, my lord,
after application, when it was notified, the folio and all everything.
the IATA my lord, sends it to the department. It has to be sent by the tribunal to the department.
When it was sent?
Then sent on 6th of February.
Then?
On 7th of February, we took my lord, steps my lord, for filing the appeal. My lord, yeah, the ward, the ITO of the ward
Then
was.
the limitation stops with the moment certified copy is applied.
Yes. My lord,
Then why there was a delay thereafter?
There is a system that the ITAT the tribunal send the order to the department.
I understand, sir.
Thereafter,
Only thing is, the moment you applied for certified copy after the order is passed, it does not require any sending of the papers. You can apply.
But here is a system that we are not applying, they are serving the
No.
department.
No.
But that
They then send to the department whatever, so that the certified copy may be prepared and given. Application cannot be denied.
maybe we not, we don't know because
You have adopted a practice that unless the record is sent, application cannot be made. That's your fault.
what is that we are following in the order sheet of ITAT, there is a stamp and receipt that ITAT order has been received. From that date, we are calculating the limitation. For 20 days, we are getting the benefit because there is a.
From which date?
From the receiving date.
Towards the provision of the limitation, where it is?
268, 268.
268?
268.
Show us.
But you should get it. The High Court may admit an appeal after the expiry
No, I'm just talking about the limitations, sir.
My lord, 268 2A.
So from the date of the receipt.
Yes.
So that was received, then why there is a delay?
But thereafter, we have tried to explain the dates wise, what the occasion arose for causing the delay,
What?
That is, on 8/12/2023,
the learned income tax tribunal passed the order. Thereafter, my lord, on 6/2/2024, the order has been received by the department. Thereafter, on 7/2/24, the appeal scrutiny report has been asked for. On 15/2/2024, the ITO prepared the appeal scrutiny report and prepare substantial question of law. On 16/2/2024, the appeal scrutiny report was placed before the PCIT 2. On 22/4/2024, ITO headquarters judicial forwarded the comments of CCIT 2 and CCIT 3 Kolkata to the PCIT 2 Kolkata. Thereafter, my lord, on 24/4/2024, the ITO Technical Kolkata on behalf of the PCIT Kolkata forwarded the comments of CCIT 2 and CCIT 3 Kolkata to the ACIT Range 11 Kolkata. On 1st May 2024, ITA 211 Kolkata submitted a report before the PCIT through proper channel. On 14/5/2024, ITO Technical sent the judicial folder to the CIT Judicial. On 3rd June 2024, ACIT Judicial Kolkata returned the judicial folder to the PCIT Kolkata. Thereafter, the appeal judicial folder was sent to the department for engagement of counsel for drafting of memorandum of appeal, stay petition, and conditional delay application. Same was received by the learned counsel on 10th June 2024. The learned counsel prepared the memorandum of appeal, stay petition, and conditional delay application on 25th June 2024 and forwarded the learned senior counsel on 26th June 2024. And after settlement, the learned junior counsel sent the copies to the department for taking necessary steps of filing of the appeal. Thereafter, my lord, some time has been taken for my lord signing and preparation of document for filing documents.
What document? Certified copy of the order is with you, received. What more document? Memorandum could have been filed immediately.
Yes, my lord, the appeals papers will not go to the my lord ITO. Thereafter, my lord, in step by step, it is go to the my lord up to CCIT. Approval has been taken. Thereafter, it has to return to the ITO. Appeals papers. Thereafter, my lord, it came to us for filing. It takes my lord some time, my lord.
That's why the legislature has given 120 days because of this.
That is true.
Either amend it and make it a 500 days because the lackadaisical attitude of the department or the officials are such that it will take a longer time to take a decision. Why 122 days? Means the legislatures were of the view everything would be finalized within 120. Nearly 400 days.
So, 400,
271. No, 371. 120 days for limitation that they consumed, and then 251 days means 371. From the date of the receipt of the order. 371 days. From the date of the receipt of the order.
that's true.
Bring that judgment of the Calcutta High Court, which is relied.
Two
Then we'll
judgments.
consider 2 judgments. When Friday you come.
Next week,
Maybe next week, my lord.
next Wednesday.
There will not be any change in the company.
No. That is
I'm not
the
expecting
Friday we need bench mamla আছে
It will not. Don't
Millard,
worry.
Friday, Millard, there are some matters fixed before the single judge, Millard. It is specially fixed. That is why, Millard. Maybe on Wednesday.
Come on, then next Wednesday, original side.
Next Friday.
Next Wednesday.
Next week.
delay control করবে না first
No.
Item number 2,
No, order name is
একই same.
This is now. Who is appearing in two?
Lord, we are appearing.
Same point.
No, no.
Millard, different point, but only the point of limitation is the same. 130 days delay.
Service.
Yes,
The service we have effected.
7th December. Yeah.
Too close a time because they have to engage a lawyer and then do it. Today is 11th.
Millard, this may be also next witness.
Next Wednesday.
Item number 3.
This is my application, my lord. 200 and
We have not served the date. There will be a record. Lord.
203 days delay, my lord.
Service.
Yes. Service.
Already.
Service. On the last occasion, we have already filed the service, my lord. Since they have received it just few days back, that is why my lord was pleased to keep it
29,
today.
11 now.
Yes.
Sufficient time is given to.
Yes, sufficient time. So your lordship kindly takes up the section 5 application once, my lord.
To service.
The order of the tribe.
Two
Yeah.
affidavit of service.
Yes.
There are two matters on that date.
9, item number 9.
9.
Different assessment here, but the similar issue, my lord. It's appearing today as item number 9.
Matter.
Yes, two different matters, but the
Yes. Limitation is?
yes,
Both the matter-
203. And in respect of the item number 9, it's 205 days. And this one is for 203 days, my lord. Now, the order dated of the order of the tribunal is 12th of December 23. And we received it on, the department received it on 1st of January 24. And the last date was 30th April 24. Now, if your lordship kindly takes up the reasons, the sufficient cause given in paragraph 3 onwards, that is the subparagraph, page 3, 3C, my lord, that there was some urgent time barring matters till 7th May 2024, which debarred them from taking steps further, my lord, because after they receive it and then they take there is a collegium, my lord, then their collegium decides whether the appeal should be filed or not. So they make a instruction to the other authorities to prepare a appeal scrutiny report. On the basis of that, whether it is a
From January till May,
Yes, my lord.
6 months. Only explanation is
Because
that because of some urgent time bar.
yes, because
Yes,
during the
so-
time barring assessments, they don't even,
Time bar.
this is also time barred, but
So
to
that is
them,
what
those are time barring assessments which they
time
give
bar.
much more priority. Those are all
Time
prior,
bar. 120 days lapse.
yes, 120 days of lapse.
So what more?
But that is the only, but if I can really satisfy your lordship on the substantial question of law, the issues before your lordship, if I can satisfy that even if it is 700 or 800 days or 1000 days, but if I can satisfy that there are substantial question of laws, my lord, then your lordship
What is
can condone it. It's no longer, if your lordship kindly comes to page 6, my lord, there are two grounds taken. That is with regard to the restriction to the addition made, and they're arriving at a conclusion that there has been availing of accommodation entries. Now, if your lordship kindly takes up to satisfy these two issues, may I place the assessment order? Only the first ground taken in the assessment order, that is at page 11, my lord. That is the issue number 1. Apropos the facts of the case, that initially there was a survey
Then subsequently, they found certain incriminating documents. So they conducted a search, my lord, and they have found that statement of one Sanjeev Kumar Singh, if your lordship kindly comes to page 11, issue number 1, the first paragraph, that a survey operation under section 133A was conducted by the DDIT investigation Kolkata in the case of Sanjeev Kumar Singh, which was later converted into search on the account of the incriminating documents in the form of red diaries, notebooks, and also finding the unaccounted, unexplained cash. During the course of search and seizure operation, it was revealed that the Sanjeev Kumar Singh is a bill master who has been involved in providing the accommodation entries in the form of the bogus bills to various parties in lieu of commission. After the search and seizure operation, intensive investigation spreading over 2 months was carried out in this case to identify the beneficiaries, as a result of which the beneficiaries were identified and the total amount of the accommodation entries of the bogus bills has been identified during the financial year 9-10 to 15-16. During the course of the search and operation, various incriminating documents were seized. There were total of 215 small handwritten notebooks and 5 large-sized notebooks were seized, which had revealed that the whole fact of the modus operandi of Sri Singh. All such small handwritten notebooks were containing details like name,
Item number 4.
service service, the envelope has returned back, my lord, undelivered with a postal remark. None found.
It all know.
We need to serve it again, my lord. It has,
Already.
we have already sent, yes, with the postal remark, no such complaint. That means there is none found. Maybe they are not there. Maybe they have moved to a different place.
The office has changed. I have ascertained from the department. Earlier it was in Kolkata, now it shifted to Siliguri. So again, I have posted.
File this, sir. Have you got the affidavit of service ready?
No, they don't need.
এই adjourn করে দাও। Affidavit of-
I have already sent, my lord. They are awaiting the report.
শেষ করে দাও, অনেক নাটক।